Morning. The meeting of the Louisiana Tax Commission is hereby called to order. The meeting is being held at the offices of the Louisiana Tax Commission at 1051 North 3rd Street, Suite 225, Baton Rouge, Louisiana. The date is Wednesday, November 19th, 2025. The time is 9 a.m. Please call the roll.
Chairman Russell,
Here?
Commissioner Leone,
Here.
Commissioner Romick,
Here.
Commissioner Guidry,
Here.
Commissioner Frazier.
Here.
5 present and a quorum.
Being there's no old business, we'll move on to the approval of minutes.
Mr. Chair, I move to approve the minutes for the meeting of November 5th, 2025.
Okay, we have a motion. Is there any discussion on the motion? Any objection to the motion? Hearing none, motion is adopted.
Shandrika Banks on behalf of the Louisiana Tax Commission. Today we have a total of 3,021 change orders. Staff has reviewed those change orders and requests to approve 2,971 and placed 43 in pending status and denied 7. Staff requests approval of these change orders.
Mr. Chairman, I move that we approve the 2,971 change orders and place 43 in pending status and deny 7 for reasons given by staff.
We have a motion. Is there any discussion on the motion? Any objection to the motion? Hearing none, motion is adopted.
Shandrika Banks on behalf of the Louisiana Tax Commission. Today we have a total of 22 prior pending change orders. Staff has reviewed those change orders and requests to approve all 22. Staff requests approval of the prior pending change orders.
Mr. Chair, I move to approve the 22 prior pending change orders that staff has reviewed and has requested approval for.
Okay, we have a motion. Is there any discussion on the motion? Any objection to the motion? Hearing none, motion is adopted.
Shandrika Banks on behalf of the Louisiana Tax Commission. Today we have 1 tax sale cancellation for Lafourche Parish due to being erroneously sold. Staff requests approval of 1 tax sale cancellation.
Mr. Chair, I move to approve the one tax sale cancellation.
We have a motion. Is there any discussion on the motion? Any objection? Hearing none, motion is adopted. Approval of the 2025 tax roll for the Parish of Cato. Ms. Malvo.
Good morning, Tanisha Malvo on behalf of the Louisiana Tax Commission. I am here to present the 2025 tax roll for Caddo Parish. We have received their affidavit, their approval letter from the Louisiana Legislative Auditor, the Quietus, and their electronic roll, their TC-33, and their millage recap and public service recaps. The electronic roll validated and balanced in our system, and the TC-33 and the millage reports also validated and matched what was in the electronic roll, and therefore we are happy to request approval of their 2025 tax roll.
Do I hear a motion?
Mr. Chair, I call for a motion to approve the 2025 tax rolls for the parish of Caddo Parish.
Okay, we have a motion. Is there any discussion? Is there any objection? Hearing none, motion is adopted. Thank you.
You're welcome.
Mr. Hoffman?
Chairman, next item on the agenda is the motion limine filed by the assessor in the DCP East Texas Gathering matter. If the parties would like to come to the tables on the motion limine, I will swear in any witnesses who will be testifying on just the motion limine. If you intend to call any witnesses, Mr. Eddington, or if the taxpayer, who's going to be presenting for the taxpayer? To the extent that you're offering oral testimony, I'll turn it to you.
Okay, we may all speak, is that okay?
Yeah, that's fine. If y'all will, stand up, you raise your right hand. Do you swear or affirm the testimony about the truth, whole truth, and nothing but the truth, so help you God? And do. Put your hands.
Zachary Mitchell.
Scott Smysterla. William Harvey. Great. Go ahead and see. In fact, I mean, y'all can pull the chairs up, but you just need to make sure that you're speaking live when you're speaking.
Okay.
Chairman, just as a reminder, you've heard these before. It's a motion to eliminate filed by the assessor to exclude certain exhibits that were pre-submitted by the taxpayer. It's the assessor's motion, so it's appropriate for Mr. Eddington to argue first, give the taxpayer an opportunity to respond, and certainly the commission can ask any questions they have. The only issue that you're deciding on the motion is whether or not you're going to consider the exhibits that the assessor has objected to.
Eddington?
Good morning, Commissioners. Brian Eddington on behalf of the Caddo Parish Assessor's Office. This is a motion in limine under 47-1989. You've heard a bunch of them. rise out of application of the rule that the tax commission's review of the correctness of an assessment is limited to the information provided to the assessor prior to the deadline for filing a complaint with the Board of Review. DCP East Texas has filed a total of 17 exhibits. We are moving to exclude almost all of those, 1 through 11, 16, and 17. The two primary exhibits are Exhibit 1 is an active sale that took place approximately a week before the protest was filed with the Board of Review. Exhibit 2 is an appraisal. With the exception of the appraisal, and we have discovery responses, they're in the record. Each of those documents was available to the taxpayer, but was not provided to the assessor until they were filed into evidence on appeal to the tax commission almost a year later. Their argument is that, well, we come under the good faith exception. There are two problems that, and I acknowledge that there are some practical problems with the sale that just took place a week before. But even if you accept their argument that that the sale, which again is the primary document they're relying on, was not available, there's also the requirement that it be produced to the assessor within 15 days of becoming availability. They in fact waited until mid-June of this year, again, when they filed it into evidence at the tax commission. The appraisal is a little different because there is a specific rule that governs appraisals. And to be admissible, the appraisal has to be ordered before the deadline for filing a protest, and it has to be produced to the assessor within the same 15 days. Neither of those facts is true in this matter. Again, through discovery, we established that the appraisal was not ordered until after the protest had been lodged with the Board of Review, and they sat on it for 90 days after receipt. Again, they never submitted it to the assessor. They only submitted it to the tax commission. The final problem in all this is even if they were eligible for the good faith, good reasons exception, that does not create a mechanism to just introduce evidence at the tax commission. All it does is it gives them the procedural right to make an application to submit additional evidence, which is remanded to the assessor. They would have had to done that before today. They did not. So for these reasons, I would request that exhibits 1 through 11, 16, and 17 be excluded from evidence under 47, Louisiana Revised Statutes 47-8, 1989. Thank you, Commissioners.
Benton, from the taxpayer?
Yeah, just. Okay, it's kind of going in and out even though I'm pushing on it. Just let me know if you have any trouble hearing me though. Okay. All right, perfect. Good morning, Commissioners. Just to reintroduce our team here, my name is Zach Mitchell. I'm with Ryan LLC. We're a tax agent representing DCP East Texas Gathering. Behind me, you may hear speak today is Scott Smystra. He's also with Ryan LLC. And then from the taxpayer side, joining me is Will Harvey. He's the CEO of Voyager Midstream, parent company of DCP East Texas Gathering. As it pertains to the assessor's motion in limine, we respectfully oppose this motion and request that the commission admit these exhibits into record. As you know, under Louisiana Statute 47, 1989, review of an assessment is generally confined to the evidence presented to the assessor prior to the deadline for filing the complaint with the Board of Review. However, the statute, we believe, also provides the commission with the discretion to admit additional evidence when that evidence is both material and when good reason exists for the taxpayer's failures presented earlier. So if you can allow me some time, I'll go through kind of why we think it's material and why we think a good reason exists why we did not submit it ahead of time. On the first point, Exhibit 1 and Exhibit 2 are kind of the two main pieces. Some of the other exhibits that follow kind of are allocations based on those first two pieces. So Exhibit 1 is the purchase and sale agreement. It confirms the $45 million sale price. This sale document is a strong indicator of market value. and reflects a competitive bidding process based on market conditions near the assessment date. The Exhibit 2 in question is a purchase price allocation study. This provides detailed allocation of assets and supports the valuation methodology. This was completed on June 2nd, 2025, well after the parish level appeal process concluded. The studies in this asset, it essentially takes the sale price and allocates it down to different assets types in question. And then the other exhibits, as I mentioned, kind of reinforce the context of the first two exhibits. We can kind of go through those in detail if you want to, but I'll skip over to kind of why we think there was a good reason for the delay. Again, we think there's a compelling reason why these documents were not submitted by the September 4th, 2024 deadline. The transaction closed on August 30th, 2024, just 5 days before the deadline. This was a sign and close deal. The administrative control of the assets transitioned immediately from Phillips 66 to Voyager Midstream under a transition service agreement effective September 1st, 2024. Because of this transition, there were internal approvals that were required before the sale price could be publicly disclosed. The taxpayer needed additional time to provide the PSA, even though it was technically signed just days prior. Again, the purchase price allocation, the Exhibit 2, was not available at that time. It was ordered on September 30th, 2024, and completed on June 2nd. It obviously was not possible for us to provide that by the September 4th deadline. But by the time both of those documents were available and cleared for release, the border review hearing at the parish level had already occurred, and the case had moved on to Louisiana Tax Commission. From there, we followed the LTC guidance. I had conversations with staff, and I was informed that there'd be a case manager assigned to our case and that we could present our documents at that time. We also made a good faith effort to communicate to the assessor side. In October 2024, we contacted the assessor's office by phone to offer the Exhibit 1, the purchase sale agreement, to see if it could resolve the matter, or we could kind of come to the table and kind of rediscuss things. And from there, they didn't really seem to have any interest in kind of opening discussions based on the document being available. So from there, we kind of waited until the LTC process started to submit our evidence. Kind of the last piece of context I wanted to add, at the border review hearing, at the Caddo board hearing, both the assessor and the commissioner acknowledged the importance of additional information. Assessor Hennington stated, this is from the meeting minutes, I quote, "They could work something out if information is provided between now and the hearing at the Louisiana Tax Commission." Commissioner Atkins also noted he tends to believe the market value over tables, the variance needs to be addressed with additional information. The board ultimately supported moving this to the Louisiana Tax Commission, specifically to allow the taxpayer time to provide information. Assessor Hennington's comments played a role in that decision. The board recognized the timing of the sale made it impossible to provide full documentation at the parish level, and that the LTC was an appropriate venue to consider the evidence and reach a fair conclusion. Just kind of wrap things up. I understand some of the intent behind the tax statute here. I assume it's to encourage, timely submission of evidence and promote efficiency at the local level. But I believe it's also written to recognize real world complexities, such as the timing of transactions, legal constraints, and other evolving documentation that can prevent taxpayers from submitting everything at the parish level deadline. In this case, the taxpayer fully met that intent. The evidence is clearly material. There is good reason for the delay. And again, the taxpayer is responsible for taxes changed hands on August 30th. It went from, to Phillips 66 to Voyager Midstream, just days prior to the deadline we're speaking on. Finally, the border review acknowledged the sale as a strong indicator of value and deferred the case to the LTC to allow time for this documentation to be available. For those reasons, we respectfully request that the commission deny the motion on eliminating amid exhibits 1, 2, 3, 4, 5, 6, 7, 9, 10, 11, 16, and 17. Alternatively, if the commission decides to grant this motion, We request that the excluded evidence be accepted as a proffer so that the issue can be preserved for further review. Do y'all have anything you want to add there?
Good morning. My name is Will Harvey, and I'm the CEO of Voyager Midstream. I just wanted to give you a little bit of context for the sort of that 10-day window that happened from close until I guess the deadline. And what I'll tell you is the morning of the 30th, which was a Friday, August 30th, we weren't even sure if we were going to close. It was a competitive process. We're a very small company, and Phillips 66 is a big company, and there were several buyers there at the end. So we were, from a legal standpoint, prepared to close, and from a funding standpoint, prepared to close, but we had to heavily rely on a transition services agreement to bridge that until February, where the transition services was going to run off and we were going to take full operations of the business. So believe it or not, the morning of the 30th, we weren't sure we were going to close. By the end of the day, we had closed and funded. I know that sounds peculiar, but that is indeed the case. And so as it relates to the PSA, that was signed on the 30th. That Monday was Labor Day. We put a press release out on Tuesday. I think that was September 4th, but there was no mention of purchase price because we had agreed with Phillips, much larger company, obviously, that we wouldn't disclose the purchase price publicly. And so as far as sharing the purchase price or any documents supporting the purchase price, we were extremely careful and had to go back to them basically and talk to them and ask them about, can we share, should we share? And us being tiny, them being a $100 billion company, we didn't want to trip anything up even after the close. So just to give you some practical insight on what was happening, there were lots of things happening in a very high-paced environment. Obviously, Caddo Parish tax matters being an important one, but one of many important ones that we were resolving at that time. So just giving you a little bit of context for that window of events.
I have a question. So so y'all closed the sale, y'all issued a press release. Did anybody call the assessor and say, hey, we just did a sale, can't give you the document yet, but can you help me out or can you work with me? Any effort made whatsoever to contact the assessor's office before the deadline? Yeah.
You need me to step up like I am. Yeah, we provide, but we reached out. I believe we had appeal to get to allow for a hearing at the board.
From other appeal.
Oh no, I meant. No, correct. So what I was trying to say is we filed the appeal on September 4th, very last minute. On that same day, we did reach out. We had a conversation. Obviously, we couldn't even tell them the price. We couldn't provide any documentation, but we kind of gave them a heads up. Hey, we need to file an appeal. We're doing everything we can to get you this information. And we had emails all through from September 4th all the way through the hearing on September 11th. We had kind of back and forth discussion and phone conversation. So yes, we did reach out.
Oh, this is for this. Mr. Eddington, do you all have any knowledge of this happening with communications, with emails back and forth?
There were. And matter of fact, the emails are in the record. There are, simply references, hey, we want to talk. And they're correct. At the Board of Review, Assessor Hennington, I'm sorry, I drew his name. He's gone. Did say, we'll talk to them if they give us information. That's the important part. Remember, I appreciate that this case is a little unique, that the sale just took place a little less than a week beforehand. And even if you accept that it was not available on that date, that's not the only part of it. Again, this is from 47/1989. Good reasons for failure to timely present documents shall be presumed to exist where otherwise admissible documents is not available to the taxpayer at the time of the deadline for filing, but is provided to the assessor within 15 days of availability. This goes back to your question, Mr. Chairman. We propounded discovery on them. We had them lay all these dates out. They didn't provide any of this information to the assessor. The first time we saw it was when they submitted it, not to the assessor, but to the tax commission on September the 16th, 2025, more than a year later. I don't know if they were intentionally sandbagging the assessor. It certainly appears that way. But the simple fact remains that yes, there were conversations that if you get us information, we'll continue to talk to us. They never provided anything to the assessor.
Questions from the commission?
Mr. Chair, I have a question for the taxpayer, just I guess in rebuttal of Mr. Eddington's recent statement. I understand the complexity and confidentiality. Why did it take that long to disclose? As I appreciate, the transition services became effective in February, so at that point, you're operating the assets. So if it is factual that information was not provided until September of 2025, what was the gap between February and 2025 where it would have been public information, I assume, that you are now operating those assets?
I think there's two main kind of dates in question. There's Exhibit 1, which is the purchase price, or not the purchase PSA, the purchase and sale agreement. That
just, all that says is the terms under which we entered the deal and the purchase price consideration. Okay, sorry. Just to be clear about what the purchase and sale agreement entailed, it had the quantum of dollars involved and the funding mechanism and the timing. It just laid out exactly how much and the mechanism by which we will fund and the assets that we were receiving. That's all it laid out. It didn't have an allocation of value to the different assets or to the different jurisdictions. It simply had a total amount of value. So,
Correct.
So I think there's kind of two pieces to that question. The first piece is the PSA. It was signed on August 30th. I guess in theory it existed that early. It wasn't available to share. We kind of mentioned at the hearing that we would get it to them when we could. So I gave them a call in October 2024 when we were allowed to share it. It was well past the board hearing, so I kind of thought all our appeal rights at that level was kind of gone. But I gave them a call and said, hey, that number we told you, the 45 million, we now have documentation to back it up. Does that change anything? Can we work out anything? I'm happy to send it to you, but if it's not if they kind of, no, we're going to go to the LTC, it's not going to change our stance. They kind of just discredited the sale as a whole, kind of saying that the sale doesn't support fair market value. So we didn't actually send it to them. In hindsight, we should have, but we gave them a call and said, hey, it's available to share. It's here. The second piece, the PPA, that the purchase price allocation, Exhibit 2, that was not completed until just a few months ago in June. At that point, we were well into the LTC process, so we thought it'd be best just to submit that, with our evidence to the LTC. I mean, it was just a few months ago, and we had already kind of had our informal meetings, and we're pretty far in depth in the process at that point.
And just to repeat, what was the date that the appraisal was ordered?
I'm gonna need Ryan to confirm, but we ordered the purchase price allocation in September of 24, so sort of less than a month after we closed, and it was finally finished by a different group, not by Ryan, a different group, in June of 25. It took that long because drafts and redrafts and comments, and so it took that long to actually finish the allocation.
Thank you.
Rich, if I might, that absolutely proves my point. Again, on the allocation, an expert report, there are very specific rules. It has to be ordered before the deadline and presented within 30 days. Neither of those are true. They ordered it after after the case had been ruled on by the Caddo Parish Board of Review. They received it on June the 5th. They did not submit it to the assessor until I believe it was September 29th. All this is in discovery. Again, their excuse is, well, we were pretty far into the process none of that relieves them from their obligation of producing this to the assessor within 15 days of availability. They did none of that. They sat on it, they sandbagged the assessor, and they presented it for the first time on review to the tax commission, which they are simply not allowed to do.
Any other questions from the commission?
Mr. Chair, I have a question. So, Mr. Eddington, you're using the term sandbagging. What would be the purpose of that?
The purpose of sandbagging is to have the tax commission review this evidence in the first instance and make the assessment. That, the whole model is built upon that this evidence is presented to the assessor in a timely fashion. Even if there are good reasons, they don't get to submit it to the tax commission for the first instance. They get to request through an application to submit additional evidence, which they did not file, to have the matter remanded to the assessor for review of that evidence. There's a series of cases going about 40, 50 years where the courts have talked about this particular strategy, that they withhold evidence from the assessor, then they submit it to the tax commission, again, for review in the first instance, in hopes that the tax commission will actually make the assessment because of perceived differences or concerns that the assessor is not going to be as favorable as they would like. And again, that's specifically why you have this rule that the tax commission's review is limited to the information presented to the assessor prior to the deadline, with a couple of good faith exceptions or good reason exceptions. But again, even those only allow the matter to be remanded back to the assessor to review that evidence. And they didn't even make that application.
Just if I could weigh in on my perspective on sandbagging, and I don't know how, I still don't know how the dates and process works. That's why we have a tax consultant. But from my perspective, we wanted to get everything in as soon as possible, because here's why. We bought an asset or a business for considerably less than the carrying value that DCP was what had it carried on from a book perspective, and the value on which they were paying taxes. So that information, that fresh information from my perspective, I wanted to get that to the decision makers as quick as possible. I think what Ryan is saying is we found ourselves past the deadline, and so the next best option was just to try to do things administratively correct. So, but absolutely no way does this help me to give you information over a year later. In fact, if I could have, snap my fingers, I would have sat down with all of you the day we close and said, this is what they're paying taxes on. This is what we just paid. It's significantly less. The whole reason I'm here and that we're spending time and money on this is because there's a major delta in those two values. And so we think we should pay less in taxes because of that. I understand that there's an administrative part of this that is separate, but I think that's kind of why we're talking about a good faith exception, because from my perspective, it would have been the best thing to do is get this done and in front of you guys ASAP. It's just the function of how things played out, what we practically had time and capacity to do as a small company. And so that's how we got to this point.
Because we're who's providing to the assessor. The purpose of this tax commission is not to be the body that judges before the assessor and the taxpayer has an opportunity to work out a value. We're here to hear an appeal of a value when they disagree. Very difficult for us when the taxpayer just gives us the information, doesn't provide it to the assessor, that the law requires to be done. So, once again, we're going to vote and we're going to rule. It's not questioning whether the validity of the document, it's not questioning the process. It's a question of there are established deadlines that have to be met. And if they're not met, very difficult for us to deviate from what we typically do. So with that, I'm going to ask for a motion from the commission unless there's any other questions. Do I hear a motion?
Mr. Chair, I move to grant the motion by the assessor.
Okay, we have a motion to grant the motion and eliminate, motion to grant the motion and eliminate. Is there any discussion on the motion? Any objection? Hearing none, motion is adopted. Now, y'all have your appeal next. The fact that we're going to exclude these documents, do you want to request an extension? Do you want to continue with the appeal today?
Yeah, I mean, we're good. Yeah, we're good. I mean, we're prepared either way, so.
Okay,
You do realize you have no evidence.
We understand.
Okay.
Right, I assume they set this.
Well, actually, Mr. Bell is.
Okay, if I can, if you'll stand up, I'm gonna mention that to you. Do you swear or affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God? Yes, I do. And your name? Rodney Bell. Great, thank you.
taxpayer first. Your value,
Yeah,
your
Chairman,
appeal.
so the taxpayer will go first. Just for the purpose of the record and our minutes, we will accept the excluded exhibits under a proffer pursuant to the taxpayer's request.
Taxpayer.
Mr. Chairman, I guess one bit of housekeeping, just so I don't keep interrupting you. The motion in limine has excluded all of their substantive evidence. I have a sneaking suspicion they're going to attempt to get it in through testimony.
We'll be on the watch out for it.
And so I would just make a standing objection for the record, that, the testimonial evidence is likewise excluded. Thank you, Mr. Chairman.
Okay, we'll hear from the taxpayer. Strongly caution you, do not refer to the exhibits that we've excluded. Stick to the couple that you have in.
Okay, to clarify there, I mean, can I talk about the cell or the number? I mean, the 45 million was talked about at the parish board level. I mean, we don't have the exhibit to back it up. I mean, can I speak on the cell at all, or, I mean, I don't want to.
You want to mention the sale, you can mention the sale. We have no document in front of us to review it. We have no means to say whether it's right, wrong, or indifferent.
Okay, well, I have what I have to prepare to say, but I won't reference any specific exhibits. Feel free to cut me off, though. I mean, I know it's kind of a unique situation, so, but to begin, I just want to provide some context about the assets under appeal, and the company involved, a little bit. I'm assuming you've all kind of looked through some of the evidence. I don't know, but,
We looked through all the evidence. That's our role
Okay.
to do.
okay, yeah, I knew it, some of it being denied, I didn't know, but DCP East Texas Gathering, it operates, midstream natural gas pipelines, primarily in Texas and Louisiana. The assets under appeal consist of approximately 14 miles of pipeline located in Caddo Parish, installed in 2012. These lines include about 12.5 miles of 16-inch pipeline, roughly a mile of 10-inch pipeline, and then 0.06 miles of 8-inch pipeline. These assets are aging, underutilized, and represent only a small fraction of the company's total asset base, which includes over 500 miles of pipeline located in Texas. As we know, there was a sale of 45 million, which includes 3 entities: DCP East Texas Gathering, East Trans Limited Partnership, and Fuels Cotton Valley Gathering. This transaction covered pipelines, processing plants, real estate, and other infrastructure, most of which are located in Texas. By any reasonable allocation, the Caddo Parish assets represent well under 10% of the total system related to the sale. I want to also acknowledge that the LTC establishes guidelines for pipeline valuation. These guidelines rely on LTC tables that calculate replacement cost new based on pipeline age, diameter, and length. From there, age depreciation factors are applied to account for physical wear and tear. However, these tables only address physical depreciation. They do not account for functional or economic obsolescence, which the LTC guidelines state must be considered. In practice, most accurate valuations require an adjustment beyond basic cost and age factors. The LTC pipeline tables are a useful starting point, especially from like a mass appraisal standpoint, but they rarely capture true fair market value without further refinement. We kind of had 3 kind of ways we viewed on how to value this pipeline. I'll kind of quickly go through these kind of 3 main ways we looked at it, and then I'll kind of recap at the end some historical evidence. We do have a couple of exhibits to go through, even though it's limited. The first valuation approach We looked at all 800 miles of pipeline involved in the sale. Ignoring obsolescence, the LTC tables indicate a total value of approximately 136 million. This is based on mileage and LTC allocation. Only about 5.39% of the value, or about 7.3 million, is assigned to Caddo Parish. So again, if you just take the LTC tables, ignore obsolescence, and apply it to the pipeline, the LTC tables would tell you the value is worth 136 million for the total pipeline. Now, when you compare that to the actual market transaction, the entire asset group sold for 45 million. Even under a conservative assumption that the sale excluded, or even under the conservative approach that the sale only included pipeline assets, which it did not, the sale price represents just 33% of the LTC derived value, implying a need for a 67% obsolescence adjustment. Applying the same adjustment to the Caddo Parish's value of 7.3 million, that gets us to a value of 2.4 million market value. This kind of the second approach we took was using the 45 million, and then we had a study that showed the actual pipeline within that sale was of the 45 million, only about 14 million was allocated to pipeline. When you use that same 5.3%, and instead of using the full sale price, you use the 14 million of the sale price for pipeline assets. That's how we get to our, we think the actual pipeline value for Caddo Parish based on that same allocation is 783,000. The third approach is we looked at the pipeline utilization, which is a critical measure of both economic and functional obsolescence. Pipelines drive their value not simply from their physical existence, but from their ability to generate revenue through throughput. A couple of key metrics we looked at was MCFs per day capacity. This is 1,000 cubic feet per day and represents the maximum volume of a natural gas pipeline. For Caddo Parish, the segments are designed for about 200,000 MCFs per day. The actual volumes from July 24 through 25 was about 5,000 MCFs per day, which is operating at about 11% of its design capacity. Why does this matter? Obviously, a pipeline operating at such a low utilization cannot command the same market value as one that's running near capacity. When you make that 89% obsolescence adjustment based on throughput, we get to a similar value of 771,000. So again, just a quick summary, we kind of had three ways to review it: the sale price allocation, the PPA allocation, and the utilization allocation. One's at 2.4 million. That again just makes the incorrect assumption that all the assets in the sale are pipeline. The second one is 783,000, and the third one is 771,000. All we're requesting today is a value of 2.3 million, 2,381, 299, which is consistent with the value we stated that was filed on the 2024 return. Some closing kind of focus on value history here. Even if you completely ignore our debate about our valuation approaches, the assessment history for these assets tell a clear and compelling story. The 2024 value of $7.3 million market value is an outlier and inconsistent with both prior year and subsequent years. To kind of go over the history here, in 2022, these same assets were valued at 4.99 million market value. In 2023, there was a 15% obsolescence adjustment to had the value at 5.47 million. And then, as you know, in 2024, it jumped up to 7.3 million with no obsolescence. And then in 2025, Exhibit 8, which to my knowledge is not denied or being limited here, you can reference the assessor's office has set the 2025 value at 2.228543, which aligns very closely to our requested value today. So again, there is obsolescence in 23, there's obsolescence in 25, and this is kind of an outlier. It's a big spike in value that's not representative of the historical pattern on how the assessor has valued this pipeline historically. The second reference I want to make is Exhibit 13, which again, to my knowledge, is not denied today. The assessor informally offered a 15% reduction in 2024, lowering the value to 6,231, 949, so 6.2 million. And then they withdrew that offer when we told them we were going to go to the BOR parish hearing. This is critical because it shows the assessors acknowledge the need for obsolescence adjustment this year in 2024. If the assessor believed the current valuation was accurate, they would not have offered us that reduction. So again, historical assessments confirm that obsolescence adjustments are standard for these assets. The assessor's own informal offer demonstrates the recognition and the need for obsolescence, and that the $7.3 million market value is excessive. We respectfully request that the commission adopt our proposed value of 2.3 million, which is consistent with our return we filed and supported by, historical precedent and LTC guidelines. If the commission does not fully agree with this position, we urge at minimum that a 15% reduction be applied to bring the 2024 value in line with the assessor's own prior adjustment and historical trends. So again, just kind of a final recap here. We believe the 2024 assessment is not just high, it's inconsistent and out of line with both market conditions and the assessor's own actions.
Mr. Eddington?
Couple questions. Mr. Mitchell, I want to make sure, you were representing DCP East Texas Gathering in dealings with the Caddo Parish Assessor's Office, is that correct?
Correct.
And how long have you been representing DCP East Texas before the Caddo Parish Assessor?
I assume what you're getting at is we represented Phillips 66 before the transition. Is that accurate? I think.
No, listen, it's the same entity. It's the same.
Yeah, correct.
Limited partner.
So I think we were represented since, or at least since around 23, I believe.
Okay,
I think we
so
filed the 24.
But you're familiar with the history of how this property has been assessed by the Caddo Parish Assessor's Office, correct?
Correct.
Okay. The tax year at issue, 2024. You're familiar with the tax commission's rules and regulations governing the assessment of pipelines, are you not?
Correct.
And you're familiar that it contains a series of tables for the valuation with depreciation curves, et cetera. Is it your contention that the assessor failed to correctly apply the tables set forth in the rules and regulations?
The tables are accurately applied to
Okay.
reach an age and physical depreciation value.
So your complaint, for lack of a better word, is that they did not grant a reduction for functional or economic obsolescence. Is that correct?
That is correct.
Is there any issue other than functional or economic obsolescence that you believe the assessor should have done but did not?
I mean,
And that's kind of an awkward question. It's not a trick question.
No.
I'm just trying to figure out, is the only thing we're arguing about functional and economic obsolescence?
anything else? Yeah, I mean, an obsolescence adjustment would get us down to fair market value.
Right. Okay. What evidence of functional or economic obsolescence did you provide to the Caddo Parish Assessor's Office in 2024 prior to filing your protest with the Board of Review?
As we discussed at length, there was no time to provide evidence at the board hearing, but there was a 15% reduction offer offered to us based on historical precedent.
I want to be clear. You didn't submit any evidence to the assessor to support a request for functional or economic obsolescence in 2024.
Based on timing, yes, that's correct.
Okay, you mentioned pipeline utilization. Big part of your presentation. You could have given that to them. Did you provide any information regarding pipeline utilization to the Caddo Parish Assessor's Office prior to filing a protest with the Board of Review?
The pipeline utilization was after Voyager acquired the assets. That's their own data. So that's from June. That's from July 24 through June 2025. So no, that was not available or acquired or
What's
presented.
the lien date? What is the date of valuation? Do you know?
1/1/2024.
Okay, thank you. No further questions. I want to bring Mr. Bell up very, very quickly. Just pull your chair up. It's tight bit. Thank you.
Okay.
Good morning, Mr. Bell. First, could you please state your name and your position for the record.
Good morning. My name is Rodney Bell. I am the Department Head of the Business Personal Property in the Caddo Parish Assessor's Office.
And you are familiar with the assessment rendered by your office for DCP East Texas Gathering LP for tax year 2024?
Yes, I am.
Listen, the evidence is pretty clear, but I want to verify. Did you receive any information in support of a request for an obsolescence reduction for DCP East Texas Gathering for tax year 2024?
No, I did not.
There was some comment a few moments ago that there was an offer, that your office offered a 15% obsolescence reduction. Is that statement accurate?
No.
Can you explain to me, do you know what he's talking about?
Yes,
Could you please explain?
I will. At the time, we had another person that was working in the office, and he has retired now. And once I found out what he was trying to offer, I told him that was not correct. We have to assess the pipeline based on the tables that's set forth by the LTC. He did not have authorization to offer any type of reduction in value without the proper documentation.
Okay. Thank you, Mr. Bell. Please answer any questions that the commissioners or the opposing parties may have for you.
Questions from the commission?
Mr. Chair, I have questions for the assessors representative, Caddo Parish Assessors Rep. To your knowledge, looking back at 2022 and 2023, was there obsolescence considered for those assessments?
I believe it was, but it wasn't authorized.
But the tax bills went out with the obsolescence in it.
Yes.
So how does a tax bill go out if it's not authorized?
You said how did the tax bill goes out if it's not authorized? Because I was not aware that the obsolescence was given based on the conversations of the previous person who was working the account and the tax representative. So I came the department head in 2023. So I wasn't aware of the prior conversations that was going on. So under my understanding, the calculations for value were not done properly according to the LTC tables. So once I found out, I wanted to make sure we did it right according to the LTC tables.
So 22 and 23, obsolescence was offered by someone that was employed by the parish assessor's office. The taxpayer understood there was an obsolescence factor being granted. Is that correct? Yes or no?
Yes, that's correct.
Thank you. So if you're a taxpayer and you're accustomed to getting an obsolescence factor for at least 2 years that the taxpayer is representing, if not more, then why would a taxpayer assume that it would just go away without
Well,
justification, especially with, as I appreciate, Mr. Eddington, Exhibit 8 is allowed, correct?
Yes.
Okay, so there is an email from the assessor's office granting a fair market value.
yes, but obsolescence only can be given if there's supporting documentation. So it was not given in the prior years, and it was not given in 2024.
So you're saying there wasn't documentation provided in 22 and 23?
Correct. Correct.
You went back to those years and looked back to determine there was no obsolescence
Correct.
provided.
There was no supporting documentation for the obsolescence provided.
So did you go back to those tax years and amend that and reassess?
No, sir, we did not.
So you used 24 as a catch-up?
No, because you can consider it a catch-up, but we also switched over to a new evaluation method of the DCF method. So we also made sure that we did it correctly based on the new.
So the rules changed?
Yes, sir.
And in 2020, so even though this email went out in August of 2025, after the rule change, is that correct,
Yes.
Mr. Eddington?
I'm sorry.
There's an email dated Friday, August 29th, 2025, whereby Mr. Slaughter is communicating to Mr. Garrett Peters of what the fair market value, we're able to grant you the requested obsolescence on the DCP account.
Again,
When was the rule change?
the the rule change had gone into place earlier that year. He's referring to a rule. It was a policy change that they had switched over to the, I'm sorry, discounted cash flow methodology as their prior baseline. Of course, they're still, as always, considering requests for obsolescence reductions as documented. There were some discussions with the staffer who had no authority, that had raised a number, but again, it was never tendered as, and there's certainly no evidentiary basis for saying that it was tendered as an offer, as a compromise or anything to that effect.
The email states that there was requested obsolescence. The role of a deputy assessor for the assessor's office is what?
To assist the assessor in the performance of the duties of that office. I mean, they're employees.
But with no authority to issue or grant obsolescence.
No, and most parishes, unfortunately, Assessor Hennington's gone. So I believe, but I can't verify that his policy was that of most other assessors, that obsolescence determinations have to be approved by the assessor.
So perhaps Mr. Slaughter had the authority under the previous assessor.
I don't know that.
Perhaps it's possible, is it not?
It's, but the converse is true. I mean, the absence of documentation,
Understood.
I don't know.
We don't know what the actual authority was.
Well, Mr. Bell would know.
And he did not give us the authority to grant obsolescence without his approval and also supporting documentation.
We don't have any documentation of that job description, who has authority or not authority. Is that correct?
We do not. We have Mr. Bell, his
Thank you.
supervisor, testifying
Thank you.
didn't have it. And
I have a question for the taxpayer. So going back, you had modeled 3 elements. The first one being the LTC tables, correct? And those were the tables under what methodology? Just based upon the fair market value of an asset or the pipe length and the pipe size and so forth and so on?
Yeah, the depreciation tables references the LTC tables that get us to the $7.3 million market value. That's just straight cost, physical depreciation and age, and not any other adjustments to obsolescence.
So ignoring obsolescence is where you came to the 2.4 million using those tables. Is that correct?
The 2.4 million is based on a 67% obsolescence adjustment. So to get from 7.3 to 2.4.
And what was your appreciation for the amount of obsolescence granted in 22 and 23?
What was the obsolescence in 2023?
2022 or 2023 is what I understand you, or
I don't know the history in 2022. I know when I looked at the history online, it shows a value of 4.9 million, which is significantly below. My assumption is there's obsolescence in 2022. To my knowledge, there was a 15% reduction via obsolescence in 2023 to get it down to the 5.4 million.
and what is your understanding based upon?
We didn't handle the appeal in 2023, but we have worked with Phillips CC6, and that was kind of based on some conversations with them, over a year ago. My understanding was that the reason that the 2023 value was so much lower is because of a 15% obsolescence adjustment.
Okay, thank you. No further questions, Mr. Chair.
I have a question for the assessor. If I heard it right, the assessment for 2025 is lower.
Yes.
Okay,
Matter of fact,
and
I could-
I'm assuming, I'm just asking, I'm assuming that documentation was provided to you to justify that value, which is why it's pretty close to what they're asking for 2024. But now that you have the documentation, you have adjusted it to the appropriate value for depreciation, obsolescence, and anything else.
That is correct.
Okay.
I can ask 2 quick questions, just top on that. Mr. Bell, your office did receive an obsolescence request for tax year 2025 for DCP East Texas, did it not?
Yes, we did.
And did they provide documentation in support of that request for 25?
Yes, they did.
And upon review of that information, again, which wasn't provided to you in 24, your office in fact granted an obsolescence reduction for 25, correct?
That is correct.
Thank you.
Any other questions from the commission? Do I hear a motion?
Mr. Chair, I make a motion to take this under advisement.
We have a motion. Is there any discussion on the motion? Any objection to the motion? Hearing none, motion is granted.
Thank you very much, Commissioners.
Is there any other business to come before the commission this morning? Okay, hearing none, do I hear a motion to adjourn?
Mr. Chair, I call for a motion to adjourn.
Okay, we have a motion. Is there any discussion? Any objection? Hearing none, we are adjourned. Motion is approved. We are adjourned at 9:55